Now, the third case that I referred to is R.G. and G.R. Harris Funeral Homes v. EEOC. That matter involves a funeral home worker who claimed she was terminated in violation of Title VII due to her transgender status. The Sixth Circuit reversed the district court's dismissal of the EEOC's claim, holding that basing an employment decision on an employee's transgender status can constitute sex discrimination or unlawful sex stereotyping in violation of Title VII. The Supreme Court has granted cert to each of these cases, and the cases were argued on October 8th, 2019, and we are currently awaiting decision. I don't think we'll have a decision on any of these cases until sometime next year, and possibly not until June of 2020. Now, I've given you an overview of these three cases, but I've really, in providing that overview, really only scratched the surface. I'm going to turn it over to Rhea to go into more depth on how we got here.
Sure. Thanks, Chris. So I think Chris's overview of the different postures in which the three cases reached the Supreme Court is actually a great snapshot of how the circuit courts have been handling these kinds of claims, but I want to do a little bit of a deeper dive. So in the Harris Funeral Homes case, as Chris mentioned, the Sixth Circuit issued a really robust ruling in favor of the employee, Amy Stevens. But that wasn't the Sixth Circuit's first decision recognizing that anti-transgender discrimination is a form of sex discrimination. And it was not even, the Sixth Circuit was not the first circuit to recognize it, even in its earlier decision in Smith versus City of Salem. So when it comes to discrimination against people who are transgender, there are federal circuit court decisions going back as far as the year 2000, so almost 20 years at this point, recognizing that anti-transgender discrimination is a form of sex discrimination under a variety of federal statutes and laws that prohibit sex discrimination, including the Equal Credit Opportunity Act, the Gender Motivated Violence Act, the Equal Protection Clause, Title IX of the Education Amendments of 1972, and of course under Title VII, the statute that we're talking about here today. So it's interesting to think about the Supreme Court granting cert in a time when you have 5 circuits over 20 years recognizing anti-trans discrimination as a form of sex discrimination with really no sort of modern reasoned decisions going the other way. Handful of circuit court opinions that were older, I think not really considered good law. Only one circuit, the 10th Circuit, has considered the issue recently and not adopted a sort of fulsome defense of transgender employees. But even the 10th Circuit, in a decision called Et City versus Utah Transit Authority, assumed without deciding that transgender people, like anyone, can bring sex stereotyping claims under Title VII, and then it rejected that particular employee's claim. So no circuit in recent history has rejected the notion that transgender people are protected by sex discrimination protections under Title VII.